Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello and welcome to this episode of Triage. My name is Victoria Hamscho and I'm an associate in K&L Gates' Washington, D.C. office, where my practice focuses on healthcare policy and regulatory matters. In this episode of Triage, we will provide an update on key developments in the 340B program, and in particular, 340B reimbursement under the outpatient prospective payment system, following the Supreme Court's decision in American Hospital Association v. Becerra. But before we get started, I would like to welcome two of my colleagues who focus on 340B program regulatory and compliance matters, Andy Ruskin and Leah Richardson.
Hello, everybody. This is Andy Ruskin. I'm partner resident in the D.C. office of K&L Gates and do 340B compliance as well as Medicare and Medicaid reimbursement and compliance, which sometimes overlaps, as it does today, with 340B issues.
Hi there. This is Leah Richardson. I am a partner in the Research Triangle Park office in North Carolina, and I also practice in the 340B and pharmacy space.
Andy, could you please remind everyone regarding the effect of the Supreme Court's decision?
Yeah, so the Supreme Court in June of this year had issued a decision that was unanimous that overturned a D.C. Circuit decision that had allowed the Trump administration to put forward a policy that required that hospitals that are 340B covered entities get paid less for their 340B covered drugs instead of getting paid at what's called average sales price, or ASP, plus 6%, which is the statutory rate for drugs that are separately payable in the outpatient context. They were getting paid at ASP minus 22.5%. The Trump administration based this on some errant data that they were able to get from MedPAC, but the Supreme Court looked very carefully at the statute and understood what the provider community was saying, which is that CMS really only has two choices. They either pay ASP plus 6% or they do a survey. And since CMS had not done a survey before launching this policy, the Supreme Court said that CMS could not pay at less than ASP plus 6%. Unfortunately, what the Supreme Court also said was CMS had kicked up some dust by saying, but we need to make sure this is budget neutral, which, by the way, it does not need to be according to a well-established case law. But in any event, CMS had kicked up that dust, and the Supreme Court said, we're not going to decide what the applicable remedy is. We'll allow the parties to figure that out on remand to the lower courts. So CMS was instructed at that point to fix this and fix it fast.
Wow, sounds pretty definitive. How long did it take for the agency to do something to implement the decision?
Yeah, so the agency started by proposing a rule in July, which it does every year with respect to hospital outpatient department reimbursement. And in that rule, they said, the decision came out so recently, we didn't have time to fix our 2023 rates, but we absolutely plan to do something about 2023 in the final rule. As to the period from 2018 to 2022, the agency hedged. The agency said, we could do this, we could do that. We're taking comments because we really don't know what to do about 2018 through 2022. They referenced in that proposed rule that that they had done a survey in 2020, which they think comports with the statute and goes back all the way to 2018 in terms of the data that was being pulled. And so the agency is leaving open the ability to do something very controversial, which would be to say, we're now paying you the exact same way, but based on a different prong of the statute. Obviously that would invite further litigation. Alternatively, they could offer to pay providers on a lump sum basis for 2018 through 2022. We'll talk about 2022 in a second. Or alternatively, they could try to be spiteful and say we're reopening every claim that exists for every provider, not just the 340B covered entities, and we're going to reprocess them in a budget neutral fashion so that essentially all of the non-340B hospitals would now be funding the 340B covered entities, And if CMS were to try to propose something like that, it would probably be just to foment dissent so that ultimately the provider community or large segments of it would find it favorable to instead just leave well enough alone and rely on the survey for the earlier years. All of that is possible. But in the meantime, CMS has no authority to continue its policy. The Supreme Court said what you're doing is wrong. So that policy could not be used as an excuse. Nevertheless, CMS continued to pay 2022 claims all the way through September 28th of this year at the reduced rate, and it said, "Oh, we'll fix it later, maybe." And then the lower court, upon remand, having received briefs from the government and from CMS, ultimately said that they were not going to allow the agency to continue to rely on this bogus budget neutrality argument as a reason for paying less than they should for the claims they were receiving. So CMS ultimately acquiesced in that and started paying at the ASP plus 6% rate for 340B claims submitted on or after September 28th of this year.
Why have they only addressed 2022 so far? What about the other years?
Yeah, the court only required that they address 2022 because AHA didn't want to bite off more than it could chew, and in terms of trying to stop the bleeding, so to speak. So the other years will have to be addressed further. CMS had a perfect opportunity in the final outpatient rule that came out in November, or earlier this month, I should say, when they ultimately did agree as to what they're going to do for 2023, pay at ASP plus 6%, but that they ultimately said, yeah, you know what, we haven't made a decision yet for 2018 through 2022. So they're still leaving all options on the table. And again, some of those options may be very disappointing for segments of the provider community. And so we just have to wait and see what the agency is going to do there. They've said that they're going to act before July of next year, which seems like an awfully long period of time, considering that the agency has been aware of this issue for 4+ years and should have had a remedy available that they were going to at least test through rulemaking and then ultimately make a final decision. So it's puzzling why the agency is doing that. In the meantime, the litigation is also going to play out, and there will be continued briefing from AHA as well as CMS regarding possible remedies for 2018 through 2022. And so either the litigation or the rulemaking will pop, but providers just need to hang tight in the meantime because everything is still possible.
Thank you, Andy. At least there's some relief for 2022. Leah, turning to you, how are providers supposed to secure that relief?
Yeah, so for claims from September 28th to the end of the year, the CMS MACs will be adjudicating those claims at the proper rate of ASP plus 6%. The MACs have also generally announced on their websites that they are willing to pay ASP plus 6% going back to the beginning of the year through September 28th if providers affirmatively reach out to them. So in other words, they're not going to do it automatically, but if hospitals reach out to their MAC, so Palmetto, Noridian, Navitas, et cetera, that they will somehow readjust the claim. So, our understanding is there's not kind of a uniform way that MACs are dealing with this. We know some MACs are just asking for an Excel spreadsheet and are doing just one mass adjustment for that 9-month period. So it's going to depend on your MAC, but we encourage all hospitals that are affected by this case to reach out to the MACs to try to get that adjustment for the first part of 2022. Another thing that hospitals should be thinking about is their Medicare Advantage contracts and reviewing their Medicare Advantage contracts and trying to recoup some funds and get that difference between ASP minus 22.5 and ASP plus 6%. Now, it's going to depend on the individual contracts, what the appeal rates are, what's the look back period, what's the process, et cetera, what is the reimbursement methodology. So all of those things are important to figure out when you are looking at your MA contracts and figuring out, well, what is this demand letter, so to speak, going to say, or appeal letter to the individual MA plans. But there is reimbursement that is available to be recouped under those contracts. We have clients that are doing that now and have been doing that. And so we would also encourage hospitals to pursue that path as well.
Thank you, Andy and Leah, and thank you all for listening to this episode of Triage. We will continue to monitor these developments. Our healthcare and FDA practice regularly advises 340B stakeholders on compliance and enrollment matters, so please don't hesitate to contact us if you have any questions. Thank you again.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.